I'm going to give it another minute just to get started, and then I'll start the presentation. I'm just going to ask Chris to enable my screen sharing. If you can hear me, Chris.
Yeah, I can hear you. We're on to that. Yeah, you should be away now, Tom.
Okay, that's fantastic. So hopefully now you can see my screen. So I'm Tom Hickenbottom. I'm a senior solicitor at Wilkin Chapman. Wilkin Chapman, if you don't know, are the largest law firm in Lincolnshire. We specialise in many areas of law, large scale commercial developments, landlord and tenant things are just one of the many things we do. We're recognised in that because we're panel solicitors for an insurance company called MSL. So we deal with hundreds of evictions and rent disputes every year through just MSL, and then we have the separate instructions directly from clients and agents. What I'm going to talk about today is the changes that have happened as a result of the coronavirus outbreak and how the government has responded to that with some changes to the way in which possession claims are being dealt with, or, as many of you will already be aware, not being dealt with. So I'm going to launch straight into that. At the moment, no possession claims under Part 55 are going ahead at all. On the 20th of March, it was originally said that those were going to be stayed until the 25th of June. As of last week, that has been changed again, and the stay has been extended to the 23rd of August. That's a 5-month delay, if anybody's counting, in which no possession claims will take place, in which there will be no evictions of anyone from any residential property. There are some exceptions to this, and they may be important depending on what sector you're in. So it doesn't apply to squatters, so people who are in properties illegally, trespassers, those applying for interim possession orders against trespassers, it doesn't apply to those also. There are also some notable exceptions that you need to bear in mind. If you're in a case that where you can agree directions, the court will allow you to make those directions and will grant the orders so that the claim can continue, but you won't be able to have hearings and you won't be able to get a final order, but at least you could progress a claim if you're in that position. It's been clarified as well that claims can be issued, so you will send your form to the court or you'll apply through the online portal. You won't then receive anything from the court. This claim will automatically be stayed, but that's important because some of the notices that you'll serve will have a shelf life and they will expire if you don't issue proceedings. So it's important that you have issued proceedings and that your claim is then in the system, albeit nothing will then happen with it. Last week, like I say, there were amendments made, and those amendments say that the court doesn't require to give any notice to the parties. You're not going to receive a letter saying that your claim has been issued, but it's been stayed. You're not going to receive anything. Having spoken to some of the courts as well, hearings are automatically being adjourned. You may, as a claimant, get a courtesy call to say that the hearing is not going ahead, but I don't expect anything in writing or anything more than that. Some courts were relisting applications in anticipation of the stay being lifted on the 25th of June for August. I don't know whether those listed after the 23rd will remain in the court lists, and you may want to contact the court to find that out, but don't expect the court to be particularly helpful in that regard because they simply don't know whether it's going to be the 23rd of August or a later date, and they may take the decision to simply adjourn and not reschedule. So we're doing this today, the 25th of June, because it should have been the day that claims were back up and running, and they're not. One thing that you need to be aware of is that these are temporary rules. They're applying to possession claims in Part 55 with some limited exceptions, and there are rules relating to residential property and there are rules relating to commercial property. I'm just going to focus on the rules that relate to residential property and what options landlords in particular have between now and the 23rd of August if they don't want to wait and see if possession claims are going to get back up and running on that date. The question I was asked this week is, can I still issue proceedings? Yes, you can. For anyone who served a Section 21 or a Section 8 notice where the date of possession in that has passed, you can issue possession proceedings immediately. I talk about shelf life, and what I mean by that is a Section 21 notice, for instance, is only valid for 6 months from the date it's served. If you issued, say, a Section 21 notice in February, but haven't issued proceedings, that notice may expire. So you need to consider, are you going to delay and possibly serve further notice, or are you going to issue proceedings now in the anticipation that your claim will be the front of the queue or towards the front of the queue once the stay is lifted on the 23rd of August. Enforcement applications are not happening. You will need to speak to the court to see whether they are accepting an application. Some courts are, and you will then form a queue. Other courts aren't accepting any enforcement applications. So check with the court where your proceedings are issued, and the bailiffs will tell you what they are and are not accepting. I've spoken to a few people recently about transfer up. It wasn't something that we did a lot of in Lincoln, but it is bigger in larger cities. It's more of an issue. London, for instance, you'd be waiting 12 weeks for a county court bailiff to enforce a possession order. You have the option at the hearing of seeking a transfer up order to the High Court under Section 42 of the County Court Act, and that would allow you to instruct a High Court enforcement officer, so the guys you see on TV, to go in and take possession of the property. Now, the reason why that's not normally an option is that the county court bailiff, you're paying a court fee of £121. For a High Court enforcement officer, you're going to be paying more. But when you think about how much rent you won't receive in the 12 weeks you're waiting for that county court bailiff, then the High Court enforcement officer's fee suddenly looks more reasonable. And if you can get the old tenant out, new tenant in, start earning a rental income again, that's going to be something you really want to consider. And not just in larger cities. Speak to the court bailiff before the hearing, and the court bailiff will tell you how long they anticipate the delay is going to be, and then you can judge whether you want to transfer it up. Just because you do transfer it up doesn't mean that you have to make the instructor a High Court enforcement officer. You can revert back. So I think that the important thing to remember right now is don't delay and allow your notices to expire. If you can issue proceedings, you should issue proceedings, simply because you don't know if you're going to end up at the back of a very long queue and then find out that you were too late to issue because your notice expired. I just don't think you should take the risk at the moment. So I want to move on to talking about rent arrears and what to do if your tenants have fallen into rent arrears, or if as a tenant you're struggling to pay your rent and you're worried that you're going to fall into arrears. Landlords are going to fall into two categories right now: those that are worried about arrears and those that already have some arrears that are accruing. If you fall into the first category, you need to take steps to protect yourself. And if you're in the second category, then you need to take some proactive steps quite quickly. So the first thing to do is check your tenancy agreement, find out when rent's payable, find out when your tenant actually pays the rent. So if it's due on the 1st, does the tenant always pay on the 2nd? Because that's when they get paid. Speak to your tenants. Make sure you've got up-to-date contact details. Make sure you've got plenty of information about your tenant. Are they working? Have they been furloughed? Are they thinking that they're not going to afford to pay the rent? Communication on a regular basis, say once a month, is going to be good. Keep that line of communication as much as possible. If it's going to be text or WhatsApp or whatever in writing, that's great, because then you've got a record of it and you can keep that. If it's calls you're making, make a note of when you called, how long the call was for, what you discussed. And don't delay if tenants start missing payments. Speak to them as soon as the payment's missed, within 24 hours. There might be a good reason. If their employer is struggling with cash flow and they're waiting for government funds to pay them, it might be that they've just been paid a day late. But there might be something more serious. And if it is more serious, it's better to know sooner rather than later. It may not be the tenant's fault, but you've got that line of communication. Use it and see what happens. If you've got a particularly unruly tenant, then you need to understand what is in your tenancy agreement to allow you to put pressure on to evict the tenant. So think about interest. It's now capped according to the Tenant Fees Act. So make sure you know you're charging the right interest and not too much. Again, make sure you're not charging fees that are in the tenancy agreement that are a hangover from before the Tenant Fee Act came into force, so that you're not going to get into trouble and it doesn't preclude you from serving a Section 21 notice. While you're communicating, it's a very good idea just to check that everything's okay with the property. We're seeing increasing defences based upon disrepair issues. There are a number of firms out there that are taking up tenants' claims, defending on the basis of a dilapidations claim that hasn't previously been mentioned, and then you get into a real battle and the tenant remains in the property while that's ongoing. So if you can have that opportunity to check, use it, because you may be well served that further on. What are your options? Tenant hasn't paid the rent. It's starting to accrue. You want to know what's going on. You've got to think about what you do next. So Section 8 notice for a fault, a breach of the tenancy agreement. But there are other options as well. So negotiation, surrender. I'm going to talk about all of these, as well as money claims. So a claim for the money rather than a claim for the possession. But I'm going to touch on possession claims anyway, just as a reminder of how useful they are. There are financial supports out there for landlords and tenants, but you have to be proactive and go out and get it. It's not going to come to you. And one of the first considerations is when your tenant falls into arrears, do you have an insurance policy that covers this? If you do, contact the insurance provider. Don't leave that to the last minute. Do it sooner rather than later. Section 8 notices, they can be served as soon as 2 months arrears has fallen due. So if your rent is payable in advance, monthly, you can serve a Section 8 notice as soon as that second month's rent falls due. So it will be the first day of the second month in most cases where it's payable in advance. It's a mandatory possession under Schedule 2, Ground 8. Now, Section 8 notices, it was a 2-week notice for rent arrears of 2 months. It's now a 3-month notice. It's an extension of 10 weeks. You shouldn't delay. I've spoken to landlords over the last 2 weeks who delayed by an additional month to see what would happen. And now they're waiting until September for their Section 8 notices and Section 21 notices to expire. If the tenant carries on not paying rent, that will be 6 months of arrears by the time that they can bring possession proceedings. So don't delay. I can't emphasize that enough. If you're having arrears and the second month of arrears of rent hasn't been paid, you've got 2 months of arrears, serve the notice and then think later whether you're actually going to issue possession proceedings. It's low cost, it's quick, and it starts the clock running. And then you can think about later. So in terms of whether it's a good idea, absolutely, it has to be done as soon as possible. Consider serving a Section 21 notice as well as a Section 8 notice. I say that simply because the arrears may be cleared by the time you come to issue possession proceedings, but you may have decided you've lost faith in your tenant. There may be other breaches and you just want the tenant out. You can then use the accelerated procedure under Section 21 if you've got that option. If you serve both notices at the same time, because they've currently got the same timescale and they're going to expire at the same time, there's no disadvantage or advantage there immediately, but you may get the advantage later down the line. You won't have got that advantage if you don't do it. Wilkin Chapman offer a very low cost fixed fee services for serving the notices. And when we serve notices, we're not just serving them on one ground. We're speaking to the landlords to make sure that we're serving them on every ground that we can, whether there have been historic rent arrears problems, whether there's been persistent late payments, whether there's been other breaches of the tenancy agreements. We need to understand all of that so that we can serve the right notice. Many tenants have been trying to negotiate with their landlords. That applies to both commercial tenants and residential tenants. It's a good idea, but it's going to be case specific whether it suits your purpose. I'm skipping ahead slightly, so I'll skip back. The more information you have going into a negotiation, the better you're going to be. So you need to know whether your tenant is still employed. Have they lost their job? Have they been able to apply for state benefits? Do they have an income? Do you have a guarantor in place on the tenancy? Is that guarantor able to pay the rent? Make sure that if you're negotiating and talking to the tenant about what they can and can't pay, that those discussions are without prejudice, and the tenant knows that the agreement still applies until you actually reach a deal. If you do reach a deal, get it in writing, and if there is a guarantor, they need to be involved from the beginning and not the end. If you change something without getting the agreement of the guarantor, you may release the guarantor by mistake. So it's always important to involve them in the process. And the same if you have an insurance policy, make sure that that policy provider is involved in those discussions. You don't want to void that policy that you may later need to rely on, but by agreeing something else with your tenant. If you can agree something, get it in writing and get it signed if possible, and consider what will happen if that tenant breaches the agreement. So, for example, you agree a lesser payment or an additional amount of money each month until the rent arrears are cleared. Consider what payments are going to be made and what will happen if the tenant doesn't stick to that agreement. Are you going back to the original agreement? Can you then enforce it? How are you going to deal with it? I've been talking to lots of tenants, particularly students at the moment, who want to ask about surrendering tenancy agreements. It's got to be an agreement, a surrender. It can't be unilateral by the tenant or by the landlord. It's got to be an agreement, and it can't be imposed on one party. Tenants are particularly keen on them at the moment where they're tied into long-term lettings arrangements that are no longer suitable for them. I say students because a lot of students signed up to tenancy agreements earlier in the year and now aren't going to university, or their circumstances have changed, other people aren't going to live with them. So, sorry, my cat's now jumping up on the table. So talk to your students, talk to your tenants who are having problems paying. Have a look to see whether there is a guarantor. If there is a guarantor, Are they going to pay if the tenancy is unpaid? Surrenders don't have to be in writing, but they should be if you can get it in writing. Surrender can be conditional upon things being discharged, so think about rent arrears. If there have been rent arrears, get those paid as part of the terms of the surrender. And what are you gaining as a landlord? Think about the long term. Are you getting rid of a tenant who can't pay and with the ability to take in new tenants? Or do you have a guarantor on the hook that will be able to pay the whole of the rent and there is good security there? Think about it. You can, under the Tenant Fees Act, charge for surrenders, and there are also damages which are capped up to the rent recoverable for the remaining term of the tenancy. If you're at the start of a tenancy, that's going to be a huge amount of money. If you're at the end of tenancy, it might only be 1 or 2 months' rent. And in terms of surrenders, make it clear that you're not agreeing until it's in writing or it's signed, or there is a clear agreement as to what those terms are. Break clauses, they are rare in tenancy agreements. I've advised on one this week, and I know of another couple that have been incorporated into tenancy agreements. They're generally only tenant-only break clauses, so the tenant gives notice to the landlord to terminate, not the reciprocal ability for a landlord to give notice to a tenant. Excuse me. If a break clause is within the agreement, it will bring the agreement to an end before the end of the fixed term. Most break clauses are prescriptive. They will say how and when notice must be given, whether it needs to be in writing, how that notice needs to be served, and there are normally conditions attached. To be effective, you will normally require a tenant to be up to date with any rent and not to have breached other terms of the tenancy agreement. If you didn't draft your tenancy agreement yourself, if you downloaded one off the internet or you're using one that you've used for years, check to see whether it has a break clause in there. You don't want to be given notice out of the blue and then have to scramble to see whether it's valid or not. Have a good record of whether a notice will be valid or not. And if there is the rare case that you can serve a break notice, make sure you have that recorded as well, so that you know when you can terminate it. And the other thing when thinking about notices, make sure you're serving them correctly, make sure addresses for service are up to date, make sure the tenant has your correct address for service, and not, for example, an old agent that you're using before, or an old address. For landlords that are facing significant rent arrears right now, who don't want to wait to see if possession proceedings will be permissible on the 23rd of August, money claims is probably the next best option for you. Wilkin Chapman offer a residential landlord debt recovery service. So go to our website and go to our recoveries pages, and you'll find out more information there. Bringing a claim for money doesn't mean that you will get paid. It means that you will get a judgment and it won't get you possession. So that could be a good thing or a bad thing depending on your circumstances and your tenant's circumstances. Before launching into a money claim, you need to decide what your priority is. Is it a possession order where you get the property back and are able to re-let that? Or have you just got a difficult tenant and the rent is the difficulty, but if you can get that offer, the tenant the relationship can then continue. And it will sometimes depend on the length of the agreement and whether or not there's a guarantor there or not. if you've got rent arrears right at the start of the agreement, but you know that the tenant has capital or money or a job that you can enforce a money judgment against, it may be a better option than somebody at the end of a tenancy agreement where you're not sure of their financial position. It's a very similar choice as to whether, when you serve a Section 21 notice and have to issue possession proceedings, whether you go down the accelerated possession procedure, which gets you possession only, or whether you use the standard procedure, which gets you both the money judgment and the possession order. For money claims, the courts dictate certain things have to happen before a possession money claim is issued. So the first thing to do is a pre-action protocol letter. It's a letter before action, a letter of claim, letter of demand. It is called different things, but it's essentially the same. It's prescribed by the relevant pre-action protocol, and it's compliant with all of the relevant protocols. You serve the letter, you give the tenant a period of time to respond or pay. If they don't do either, then the next stage is to issue proceedings. Now, if you've got a guarantor, excuse me, you're going after the guarantor and tenant, because why wouldn't you go after both? If you've got more than one tenant, again, you're going after all of the tenants, not just one of them. So it could be more than one letter, but the proceedings will be against the same people. It's one set of proceedings. If you've not paid, having served that letter of demand, then the next step is issue proceedings. It's not a case of entering into a long period of correspondence. Rent arrears, it's a simple contractual obligation. If you've not paid and they're not responding, then the next step is to issue proceedings. The claim form is completed and sent to the court. That's either a paper form or it's completed through money claims online, and it's sent to the court. The court then send it to the tenant. Now, I have to say at the moment that the courts are suffering some staff shortages, and it's not as quick as it used to be. Normally, you would issue a money claim and you would expect the debtor to be served by the court within a couple of weeks. It is taking longer than it normally would because a lot of the court staff aren't working from the office. If once it's issued, the tenant doesn't respond within 14 days at all, you can then request judgment, or if the tenant acknowledges but then doesn't defend, you can have your judgment within 28 days. It's a judgment in default, and that judgment can then be enforced. High Court enforcement officers, I know, are still enforcing money judgments. There's also paper applications that you can make that don't need attendance in person. So it depends on how you go about enforcing it. The judgment's normally payable within 14 days. And then once that period is passed, it's a decision as to how you go about enforcing it. Attachment of earnings order, if you know where the tenant's working. County Court bailiff if it's below £750. High Court enforcement officers if it's more than £750. You might need to trace your tenant if they've disappeared, or if you need to gather more information. Wilkin Chapman, our debt recovery scheme, has those services available as an add-on. And it's low cost, and the reason it's low cost is because most of these claims will be under £10,000. That means they're a small claim. You will recover fixed legal costs, which will be a tiny amount, and you don't want to be spending a huge amount of money on legal fees. A lot of people ask me, what are the advantages and disadvantages to bringing a money claim? The advantage is you're going to get an order very quickly if it's not defended. If it is defended, you can still apply for summary judgment. That doesn't, in most tenant claims, there's generally not a good reason for not paying the rent. It doesn't end the tenancy, so it keeps the tenant on the hook. That's particularly useful if you've got a guarantor. And biggest advantage right now is that it's not affected by the stay of possession proceedings, so you can carry on. Disadvantages, you can't then rely on the same arrears to recover possession down the line. So you need to wait for further arrears to accrue and then pursue possession proceedings on that basis. Now, at the moment, if you've just served notice on your tenant who's in arrears, it may be entirely possible for you to get judgment on those arrears, and then by the time you get to a possession hearing, you will have new arrears that you can rely on, and then you get a second judgment in those proceedings. So it depends on the circumstances and what you're prepared to do and how quickly you want the money as to whether it's a particular advantage or disadvantage to you. Judgment is just a piece of paper. It's nothing more than that. If it's not paid voluntarily by the tenant, it needs to be enforced. That's a different procedure. Enforcement comes after judgment, and it can potentially be a long process, particularly if it's defended robustly and there is some genuine defence there. It can be a longer process in the same way that possession proceedings can be a longer process if they're defended. It's a good idea to bring a money claim if you've got considerable arrears and you're facing a long prospect of not being able to recover the tenant. It's a better idea if there's a guarantor or somebody else there, or you know the tenant has significant assets. Statutory demands are a precursor to bankruptcy. You can only serve them on an individual where the debt is more than £5,000. It is a cheap option to begin with, but can become quite expensive quite quickly. I say a cheap option, standard form, that's very simple to complete. That does then need to be personally served upon the debtor. And then they have 21 days in which to pay the debt. If they don't do that, you can then make them bankrupt by applying for their bankruptcy. The bankruptcy process is where it gets expensive because the court fees are quite considerable. You have to assess it on a case-by-case basis whether you'll incur more fees going through the county court process for a possession or money claim, or whether bankruptcy is the right option for you. There's no two ways about it, because the fees rack up quicker. It's worth checking at the beginning whether it's going to be more advantageous for an individual landlord. New legislation that was introduced during May means that statutory demands against companies for their company being wound up can't currently be served. That is going to apply until either the 30th of June or 1 month from the date the Act comes into force. I checked yesterday. The Act isn't in force as far as I can tell, which means it's going to push past the end of June. But if you've got a company that's a tenant, statutory demands are a good way of paying. The advantages and disadvantages of these compared to money claims are that money claims, in most cases, is going to be cheaper unless you've allowed considerable rent arrears to accrue. Then the court fees for money claims are going to be lower. But a statutory demand is a very useful threat against somebody who has assets, so particularly guarantors. It can be a much better way of getting payment, and serving both the tenant and the guarantor can be very effective. So that's all I've got to say in respect of money claims. I just want to say before we go on any further that there is a question and answer box at the bottom of the screen. I'm going to be taking some questions in a short while. If you want to start adding your questions to that box, I will look at them very shortly. Just bear with me. So I want to talk about, no, we're not doing questions just yet. We're doing updates first. So there's some legal updates that really slipped under the radar because they've all come in while the lockdown has happened. and they're still applicable. The government, despite lots of people thinking they would, didn't delay anything. And so these really have slipped under the radar and may be missed by a lot of landlords, a lot of agents, and potentially a lot of tenants as well. So the Tenant Fees Act came into force initially on the 1st of June. That applied to new tenancies, and from the 1st of June 2020, it applied to all tenancies. So it's only recently come into all of those tenancies that weren't already covered are now covered by the Tenant Fees Act. Sorry, my cat's come back to bother me. Don't get caught out. The payments are prohibited unless they're set out in the Act. So the Act is quite easy to read, but basically no setup fees, no viewing fees, no credit checks, no inventory checks, cleaning fees, missed appointment fees, none of those can be charged. The charges are really, really limited to rent and a few other things. Deposits are now capped in most cases, so where the annual rent is less than £50,000, your rent is capped, so your rent deposit is capped at 5 times the weekly rent. Interest is now capped at 3% above the base rate, and there are other capped costs as well. So you need to think carefully. If you have an old agreement and you are still looking at that for what you can and cannot charge, bear in mind that some of those payments may now be prohibited as of the 1st of June. Don't charge them, because if you do charge them, then the Section 21 notice will no longer be available to you. It's very key that you don't charge them, even if they're in the agreement. Section 21 notice is just one of the issues if you charge those fees in breach of the Act. The other is that the penalties range between £5,000 and £30,000 depending on the offence that's committed. So it puts landlords at a considerable disadvantage if they don't know what they're charging. So please take a careful look at that before you render any late payment charges at all. Now, EICR, Electrical Installation Condition Reports. This is in force from the 1st of July. The Act came into force, came into being at the 1st of June, but it will apply to all new tenancies starting on or after the 1st of July, and it will then apply to all existing tenancies from the 1st of April next year. Requires testing to the 18th edition. It's a very short statutory instrument, so if you want to look up electrical installation condition reports, it's only a couple of sections long. It is quite easy to read as well. 18th edition with retests every 5 years, unless the report says otherwise. The report has to be given to the tenant in the same way you're already giving gas safe certificates, EPCs. It has to be given at the start of the tenancy. I haven't seen anything that says the Section 21 notice can't be served without it. I may have missed that, I'm not sure, but don't take the risk, because the penalty for not doing it is up to £30,000. It's something that's going to be enforced by the local authority, and I imagine that they will do these checks at the same time that they're doing all of their other checks. So in particular, if you are in an area that is where the residential let properties are licensed, the local authority are going to be coming out to check that you have these on your new tenancy agreements, and then on all of your tenancy agreements from the 1st of April 2021. It's worth getting those done sooner rather than later, and because they're going to be valid for 5 years unless there are works to be done. Now, if there are works to be done, they have to be done in 28 days unless the report says that they're urgent work. You have to provide the report to tenants on request. You have to provide the local report to the local authority on request. And going forward, I can only imagine it's going to be added as a precondition of serving a Section 21 notice. So make sure that it's part of that pack that you give to the tenant when the tenancy starts. I know that some agents are rushing to get tenancy agreements through so that they start before the 1st of July, not because they want to avoid doing this, but because there are so many electricians that are tied up doing other things. And there are tenants who are shielding and don't feel comfortable having electricians come into their properties. So make sure that if you are starting new tenancy agreements, that they're after the 1st of July, that they are signed up to the new electrical safety reports. EPC, this slipped under the radar simply because it was the 1st of April and everyone was busy thinking about other things at the time. But it's now all tenancies have to have a minimum EPC rating of an E. I think most people knew about this because it's been a long time coming, but there are the odd landlord who simply don't have the EPC done for the property and don't know whether they're compliant or not. It's not worth taking the risk, so get it done, because if it comes back and it's less than an E, you're going to have to do some work quickly or find that it meets one of the minimum exemptions. And finally, repairs and statutory inspections. In terms of what's changed, nothing has changed. The government didn't relax any of the rules in relation to repairs beyond saying that, bear in mind that non-urgent repairs will take longer, which they will, but urgent repairs still have to be done, and statutory inspections for things like checking smoke and CO2 detectors, for gas safe inspections, they all still have to be done. The obligations on landlords haven't relaxed. Make sure that if you are needing to carry out these inspections, that people carrying them out are doing so safely, complying with any social distancing rules, and that they get done as soon as possible. Don't delay because of what else is happening. Hopefully we will have some questions in the chat box, so just let me have a look. So please feel free to keep asking questions and I will answer these best I can. So first question about tenants who have fallen out and one of them wants to leave the tenancy agreement. What can you do to sort that out, and what can be charged for that new arrangement? So there are two options really there. The first option is to surrender the existing tenancy, for which you can charge a reasonable fee. I think that the fee suggested in the Tenant Fees Act is £50 or a reasonable fee. Well, if you're being charged £100 or £150 by the solicitor, then I think that the reasonable fee is the £150 or whatever you've been charged. So then it's a surrender of the existing tenancy and a grant of a new tenancy. And I say that might be one option because the remaining tenant may not be a tenant covenant as the two tenants together. They may not have a strong a job. Their financial position may not be as great. On their own, you may want to add a guarantor. So that's the first option. And the other option is a release of the existing tenant with the remaining tenant having an assignment of the tenancy and providing an indemnity. That's the other option. That would be a variation of the tenancy, and I think the Tenant Fees Act allows you again to charge a reasonable fee. So it's what you're going to be charged for doing that, or a nominal fee if you're doing it yourself. Let me just have a look what else we have. Question about success of money claims for tenants with benefits. That really depends on the enforcement. In terms of getting judgment, yes, that's a good success rate. In terms of enforcing those judgments, it depends on the individual circumstances of the tenant. We use a firm of High Court enforcement officers who are very good, and I think I've only had one in the last year return paid, and that was because the tenant was elderly and ended up in a care home. The others do pay. It may be a nominal payment over a period of months or years, but generally speaking, they do get payment. It really depends on the specifics. If you have any debt over £750, then a High Court enforcement officer, I think, has got to be the way to go. Sorry, just having a look at some of the other questions to see which ones I have and haven't answered. So a question about student lettings. One tenant that's not paying and an incorrect guarantor. That's a difficulty for you. Okay. So money claim is not related to the 23rd of August. You can bring a money claim at any time. Your circumstances there are going to depend on whether your tenant is on a single tenancy agreement or whether you have students that are on individual tenancy agreements. That's going to affect how you decide to deal with this. So if you've got one tenancy agreement, provided it says that the tenants are jointly and separately liable, you could choose to go after the other tenants for the unpaid rent. That's the advantage to you as a landlord, and that's the disadvantage to the tenants in that. So consider going, depending on the circumstances of the tenancy agreement, consider going after all of them or the single one of them. And if the other tenants are good, they may be able to push that other tenant out if they're not paying the rent, particularly if you're going to either bring possession proceedings against them or a money claim against the others. That's very good pressure in order to force them into either making that tenant leave, and then pressures from them, not from you, or you're going to be able to enforce that against the others and the other guarantors as opposed to the single tenant. So I've got a question about ad hoc payments, but still owe a considerable amount of money. What notices can be served? Section 21 or a Section 8 notice? In that case, if you're within 3 months of the end of the fixed term, or the fixed term has already ended, then your Section 21 is automatically applicable. If the amount of money that you're owed is more than 2 months' rent, even if it's accrued over more months, you'll be able to serve a Section 8 notice and rely on the mandatory grounds. So mandatory ground means when you get to the possession order, the court must order possession. But also you've got in there discretionary grounds such as persistent late payment of rent. There are some rent arrears outstanding. So when you're serving your Section 8 notice, you're going to be relying upon multiple grounds within that Section 8 notice, and that gives you a very good prospect of getting possession. Or you've got the option of, if you're outside the fixed term, your Section 21, and you will follow the standard procedure, and then you will get a judgment for your money and your possession claim. And at the moment, I would serve both notices because the time period's the same. If we were in normal circumstances, I would be saying serve your Section 8 notice and maybe serve your Section 21 notice as a backup. Sorry, I've got a question about pre-action protocol. So the private rental sector, there is a standard protocol, two standard protocols that you may want to consider. One is the protocol for debt claims, and the other one is just the general pre-action protocol for conduct. Generally speaking, it's the conduct one that will apply to most landlords, but there are some circumstances in which the debt protocol will apply. It's different slightly from the social landlords protocols because it's designed for a layperson to do rather than a local authority. I'm not aware of anything that allows you to find out if a tenant is in receipt of housing benefit. It's got to be a conversation that you've had. And just for clarification on that other one, we've got it's one tenancy agreement for 3 students. So in all likelihood, you've ended up with 3 tenants on the hook for all of the rent. So you probably be able to intimate claims against each of the tenants, and that's going to be the way that you push things along. Okay. Right, well, I think that is everything. Thank you all for joining in today. I hope I've been able to give you some useful information. Please feel free to contact me after today. My details are on Wilkin Chapman's website, and details of our Help for Landlords scheme can be found there, as can details of our debt recovery scheme through our recoveries team. But thank you very much